My name is John Ray Clemens. I'm an attorney here at the Nashville Bar and Tennessee Bar, and I have the pleasure of interviewing Mr. W. Gary Blackburn for the purpose of the Legal History Project of the Nashville Bar Association. Mr. Blackburn, if you would just go ahead and give your full legal name and your date and place of birth.
William Gary Blackburn. I was born in Knoxville, March 15, 1947, during the administration of Harry S. Truman.
And did Harry S. Truman have any particular impact on you as a newborn?
Only my mother's complaints about him because she was a Republican.
Now,
and he did appoint Judge Taylor in Knoxville.
Now, did you enjoy growing up in rural East Tennessee, or did you live there your whole childhood?
When I was young, very young, I lived but then it was called the old Maryville Highway. It was between Knoxville and Maryville. Pretty lonely place out there. When I was in grade school, we moved to Morristown, which is about 40 miles northeast of Knoxville. I wound up graduating from old Morristown High School, which today is Morristown East, and I very much enjoyed living in Morristown. It was a great place to grow up.
Now, how many people were in your graduating class from Morristown High School?
There was about 380.
And so what was your community like where you spent most of your childhood?
Well, it was like any other small southern town at the time. Everybody knew everyone. It was segregated, which was, in retrospect, hard to believe, but it was segregated all the way through the end of my high school years, which was 1965. We played ball. I wasn't big enough to be in the high school football team, so I played in the band. Went to a lot of interesting places in the band and got a lot out of it. It was a it was a place where you felt like you could achieve some things on your own. It was not terribly socially stratified. There were a few people who had more, of course, were more prosperous, but it wasn't glaring. There was not a private school in the entire county. There were no charter schools. There was my school.
Now, did you enjoy sports as a child? I think you told me once about how you won a television and you got to watch your baseball games.
Yes. Well, we played sandlot football all the time, like every afternoon in the fall. I played basketball more than anything else. There was a grammar school near where I lived, and that had full court on asphalt. I left a lot of flesh on that asphalt over the years. Played there 2 or 3 hours at a time, several days a week, and during the summer especially. It wasn't hard to get up a game. There was always people showing up there. I visited this last 2 weekends ago in my high school reunion, and I noticed to my dismay that they had increased the goals. It was a grammar school, and we'd played on these 8.5-foot goals so I could dunk the ball, but now they're actually 10 feet tall, so I was very disappointed in that.
So coming out of Morristown, you obviously went to college, and so if you don't mind, tell us where you went to college and how you chose to go there.
Well, I went to the University of Tennessee, where I was from. If you wanted to party and weren't very serious, you went to East Tennessee State. And if you had some money, you went to places that none of us had ever heard of. If you wanted to be a serious student, you went to Tennessee to the extent where it was just called the university. That's all anybody said. I went there primarily because it's what I could afford. My father was the snap-on tool man for Upper East Tennessee. UT Knoxville was $270 a year tuition, including the student activities fee when I started. My dad cashed in a bond he'd had since the World War II, to pay for me to live on the campus that first year. And I got a great deal out of it. It was a baffling place. It was larger than my hometown, the college was. Everything that you want, good and bad, is at a place like University of Tennessee. If you want to be a scholar, it's there. If you want to party nonstop, it's there. I'd say the latter is more popular than the former.
Well, as most of us here in Tennessee do, we judge kind of timelines based on who the head football coaches were or sports coaches. So who was the head basketball coach during your time at Tennessee? And who was
Ray Mears. Ray Mears, the man who invented Big Orange Country. I was a huge basketball fan then and now. The football coach that came in right before I arrived was Doug Dickey, and he took the program back from mediocre and worse to being a national contender during the time that I was there. Very exciting time in football and basketball there too, really.
And who were the most popular athletes in the sports?
Well, the first football hero I ever had was when I was in grammar school, and it was Johnny Majors. I had his number 45 stenciled on my notebook. When Doug Dickey brought in all of these players, there were a whole lot more to choose from. The first black athlete ever at Tennessee came during that time, Lester McLean. There was an odd sort of guy, but a great quarterback named Dewey Warren, who was called the old swamp rat, and he was definitely a swamp rat. People like Charlie Fulton, who was from Memphis. Larry Severs was one of the last great tall white receivers in a conference that was still mostly white. The influx of these great African American athletes had not started yet. It started a little bit after that.
So as most of the young men of your generation, military tensions were high in the country at that time. Did you ever have the opportunity to serve in the military, or did you ever have any service? Well,
I tried. There was tense. It was a how would I put it, evocative time to be an undergraduate. The fall of 1965 was my freshman year. That was the year of the first big buildup in Vietnam by President Johnson, 100,000 new troops. In the dormitory, they would post maps of Vietnam on the wall saying, if you don't study, this is what's going to happen to you. The war was obviously not popular. Even at a conservative place like Tennessee, it was not popular. So my freshman year, I went down to the Marine Corps recruiting offices, and I signed up for the Marine Corps platoon leaders class. My dad had been a Marine, and he didn't want me to go at all, but he thought anything but the Marines was a little sissy, so I signed up for it. Well, it turns out I didn't qualify on the vision, and so I didn't get admitted because of the vision. I think 4 years later that would not, I think they would have taken me with a prosthetic leg by 1969. But that was turned down. So then later I tried to enlist through the ROTC, and then by that time I was on a plane ride on university business, student government business, and I had a terrible event that happened with my inner ears, and because of that, then they concluded they couldn't fly me in unpressurized aircraft, so they turned me down. I respect those who went. I have a lot of friends who went. I'm not disappointed that I didn't go.
And you mentioned your father, and your father served during the war, correct?
Yes, he was in the 3rd Marine Division, 9th Marines, Company I. Yes, I did grow up with it. And he was on Iwo Jima when he was 19 years old. I came to see later, when through my work I learned what PTSD was. I came to notice aspects of that in him that I'd never thought about before in that context.
Now, did he ever talk about serving in the war much as when you were a child, or did it have any great impact on you? I mean, aside from characteristics and kind of personality issues.
Yes, well, years later, when I was young, he wouldn't listen at all. But when I was older, I would come to visit, go to football games or whatever with friends, and he'd have a couple of gin and tonics, and I was able to get him to talk about it. It was an amazing experience for a rural East Tennessee boy at 19 years old to experience something like that. Someone sent him a picture of like a 8x10 glossy, and he was in it, and he remembered the picture being taken, which I thought was amazing. But someone had climbed on top of an overturned, destroyed Japanese tank and took the picture, and so you're looking at your dad, who's 19 years old, in that environment. And he went through the picture and he said, this man bled to death, this man was killed 3 days later, this man died in my arms.
Wow, now, you know, that would have any profound impact on any young man, especially. So, I mean, did that play any role in your desire to serve in the military? Or a lack of desire?
Well, it did to a degree, because you know, he was in the Marines for 9 years, and he would have been a lifer, except for my mother, who didn't want the lifestyle, didn't want all the moving. So I grew up with the Marines. I mean, he always said, once a Marine, always a Marine, and it's true.
Now, when you were in college, I'm sorry, I should have asked you this earlier, what years were you in at the University of Tennessee, Knoxville?
65 to 69.
Now, what type of activities? You mentioned student government. Any significant activities that you took part in while you were a student?
Well, the most significant, there were two significant things actually that I did that are related. I was heavily involved in student government. I became a student senator and one of the so-called vice president positions. The president that year was Chris Whittle. Whittle Communications was the last business he had associated with Tennessee. What is now the federal courthouse complex in Knoxville was Whittle Communications, that location. Chris and I went to the National Student Association Congress in Manhattan, Kansas in the summer of 1968, and saw a lot of things, saw the draft card burnings and rampant drug use, and also saw a group conspiring to disrupt the Democratic Convention in 1968. We came home and we invited the black comedian Dick Gregory to speak on the campus. This was not going to be a comedian, not going to be a comic presentation. He was one of the most powerful civil rights orators ever, very powerful. And the chancellor at the time, Dr. Weaver, vetoed the contract, said that we couldn't invite him, refused to sign it, and said publicly the reason was because his views were not consistent with those of Tennesseans, which of course made it a First Amendment case. So we got together in the student government and put all our names in a hat to draw to see which name would be listed on the complaint to sue the University of Tennessee. My friend Jim Smith was the one who was drawn. Jim had considerably different political views in those days. And his name was drawn, so that's Smith versus the University of Tennessee. It's 300 Fed Sup 777, and we won. And it was inspiring in its own way. I later appeared before that judge as a lawyer, Judge Robert Taylor.
And if I'm not mistaken, Mr. Jim Smith changed his name. Is that correct?
Changed his name to Jim Somerville, and served one term as a state senator from Dixon.
Now, prior to heading to law school, I'm curious, how did your interest in the law begin? What made you want to attend law school?
Sometime, I believe, probably around 1954, time I would have been 7. My mother was downtown in Knoxville. This was at a time when people used to dress up to go downtown. Women would wear hose and gloves and hats, and men always wore coats and ties. My mother grasped me by the shoulder and turned me around and pointed to a man on the street. She said, "Look, that's Mr. Jenkins. He's a lawyer." Well, I had no idea what a lawyer was, but I thought if you pointed them out on the street, it must be sort of special. Little did I know. And turns out this is the great Ray Jenkins. Ray Jenkins had become famous because he was counsel to the committee in the Army McCarthy hearings. That was the first congressional investigation that was televised. So in retrospect, I think my mother was pointing him out because of that fame and his notoriety. He later was acknowledged as one of the great trial lawyers ever in East Tennessee or anywhere, and did a great many things that you and I would be at least held in contempt for today. When I was at the U.S. Attorney's Office many years later, I had his memoirs called The Terror of Tellico Plains. And I knew that Judge L. Clore Morton, who was from Knoxville, knew Mr. Jenkins. And we talked about him a good bit. And I tried to give him that book, but Judge Morton was so straight-laced, I guess you could say. He borrowed it and returned it, but he would not allow me to give it to him because he was a judge. And he said that Mr. Jenkins would try a death penalty case, and regardless of the outcome, he stayed drunk the entire week following. Now, Mr. Jenkins has passed on, so I can say that.
Wow. So going to attending college with that kind of early childhood experience in your mind, and then attending college during pretty volatile years in society across the country, I suspect that played a role in your interest in going to law school, or did you have any other kind of, icons, so to speak, who you really thought a lot of in the civil rights movement that were lawyers?
Well, what people don't realize now is that the time period that I grew up, in which I grew up, the lawyers were presented as heroes. I read books about Clarence Darrow, even when I was in high school, for example. I became very interested in the Scopes trial in Dayton. There was a program called The Defenders that was about these two men who were defense attorneys, criminal defense attorneys. And then, of course, in high school, the movie To Kill a Mockingbird came out. One of the great heroic presentations of a lawyer ever. And so my mental view of a lawyer was that it was a learned profession, and that it was an opportunity to do good, and I'm sure, being human, it was an opportunity to gain the kind of respect that someone in my socioeconomic class had not had. That was true as well. And so in terms of the civil rights movement, I remember like it was yesterday when Dr. King was assassinated. And I, early on, even in my high school Republican days, identified with Dr. King and thought that if I were black, I would be doing what they were doing. And I wasn't brought up with any racial antagonism, whatever, neither of my parents. Later, there were people like Bond, what was his name, from Atlanta? Julian Bond. He was a very impressive man. We persuaded Julian Bond to turn down his invitation to speak at UT Knoxville after the veto of Dick Gregory. I became sort of attached to the idea that it wasn't just money making, that you could make a difference as a lawyer. And I still think that's true.
I'm curious, in the University of Tennessee in Knoxville, sitting there kind of in the foothills of the Smokies, were you insulated at all from these national events that were going on, or did you feel them? Was it really active presence on campus, or?
Well, we weren't Cal Berkeley. We had, it was organized in a different way. Those who were war protesters were a smaller group than you would have elsewhere. But when we began in 1965, UT Knoxville was as close to Animal House as you can imagine, including the fellow, the ROTC guy with the silver helmet. By the time we were juniors, nobody was wearing the V-neck sweaters and the starched shirts anymore. It was about blue jeans and your shirt tail out and your hair long in what we call Jesus sandals. I don't know if they still exist.
Birkenstocks, I think they are now.
Are they Birkenstocks?
And they're quite
Yeah.
popular yet again, I think, for the fourth time in history.
But there was one thing almost all of us agreed on, and that is we love the Vols. But there was my senior year, we had a student government election. There was a fellow from Springfield, John R. Long. John may have become a lawyer later, I'm not sure, but he seemed to have been elected. There was a protest, and we had this student tribunal. They set aside that election on a basis that I know today, having looked at these separately, was an absurd basis. But we were all kids. They set it aside. So they reheld the election. There was a guy named Brown who ran in this re-election, and he affected this H. Rap Brown look. And he had the afro and the goatee and mustache and the dark glasses and so forth. I said Brown, Jimmy Baxter, that was his name. But intentionally affected this H. Rap Brown demeanor, and he won. Now that shows you how much UT Knoxville had changed. He was our excuse for a campus radical. Years later, he became an assistant United States attorney, a federal prosecutor.
Wow. Now, where did you attend law school?
I went to Vanderbilt Law School. I started in August of 1969. I wasn't sure. I'd never really spent any time out of East Tennessee, and I wanted to have some other experience. And I got waitlisted at Michigan, but admitted to Vanderbilt. So I came over, and I fell in love with Nashville. Love Nashville, still love Nashville, and been here ever since.
And so what made you want to apply to Vanderbilt in Michigan of all the schools?
I had a very close friend of my mother who had been sort of a mentor for her, who was a nurse, and she had gone to nursing school in Ann Arbor. And she talked to me a lot about it, persuaded me to apply there. There was an attorney in Knoxville who was a Michigan graduate who wrote a nice recommendation letter for me. As to Vanderbilt, I was intrigued by being in the state capital, and I knew that if I wanted to practice outside of Tennessee, that they'd have a better placement program at Vanderbilt than they did at Tennessee at the time. The University of Tennessee Law School has become really an outstanding school. There were a number of changes that happened after I graduated that weren't in place at that time, and it was just not as good a quality. It's produced some very good lawyers, but Vanderbilt was considered much better then. I think if I were making the same choice today because of the cost, I'd probably stay at Tennessee.
And so what was the Vanderbilt Law School environment like? I mean, what did Vanderbilt Law School look like in August of 1969?
It was much more Spartan than it is today. It was essentially all men. I saw my classmate Bill Koch, who, as you know, has been Chief Justice of our Tennessee Supreme Court. I saw him at an event a couple of years back, and I said, Bill, do you realize there are more women judges in Nashville now than there were women in the law school when we were there? And he says, I'll go you one better. He said there were more women on the Supreme Court than there were in our class. We had 2 women in our class. And it was a, I don't know how to put it, a testosterone-filled experience. Lots of jealousies, there was someone who, this is long before computers, there was one fellow who clipped out all the articles in a law review that he thought would show up on a test so that no one else would have access to them. That happened when I was there.
I had certainly my share of interesting professors in law school when I attended. Were there any of particular note or memories of yours about professors? I know that the reputation is that once upon a time law professors were a lot more strict and demanding than current times, but
I can't speak to now, but that described them then. There was Mr. Hartman, Paul Hartman, known popularly as the Dutchman. And he had a very intimidating air to him and would say things that I suppose you couldn't get away with today. Some are just funny. You'd give a case, you'd answer, and he'd say, "You had a home run, but it curved foul." Like that. But he told one of my classmates one day that answer should leave a dark brown taste in his mouth. I'm not sure you could get away with that today. But the idea of humiliating a law student while he was required to stand on his feet and give a case was just part of it. It was like boot camp. And I'll tell you this, I don't think there's better training than that, at least not for what I've done.
And you mentioned Justice Koch was a classmate of yours. Are there any other lawyers that you've had experience with who have gone on to do?
Oh yes, John Rowe, who's the founders medalist in our class, one of the great transactional lawyers in Nashville, Sherrard and Rowe. Tom Sherrard was a professor at Vanderbilt at the time. Ed Yarborough, who later became the United States Attorney, was in my class. Tom White, who is the premier zoning attorney here. The joke about Tom is that if you want to tear down the cathedral and build a Popeye's chicken store, Tom's the one you'd go hire to get that done. There are a number of others. We had Paul Kurtz was a classmate of mine. He was a clerk in the Sixth Circuit and wound up as an associate dean of the law school at Georgia. We've just they've spread out to a lot of different places, but it was, despite my presence, a distinguished class.
And while you were going through Vanderbilt Law School, did you know exactly what you wanted to do when you got out of law school? Did you know you wanted to be a litigator? What did you aspire to be?
All I ever wanted to do was try lawsuits. That's all I ever wanted to do. And I understood that I probably, in terms of personality, did not fit that well in a larger environment, larger structured environment. About 90% of that was naivete, but that's what I wanted to do. And I wound up, I practiced on my own for a time with Malcolm McCune, who was a year behind me, but I'd grown up with Malcolm. We had a partner who stole from us. Probably shouldn't mention his name, although he has served state and federal time. And because of that, both of us having young children, I went with Ortale, Kelley, Herbert, and Crawford, and Malcolm went over with Jack Madden's firm. And I got a great deal out of that experience. I'll tell you this, in the early 70s, a young associate was paid $1,000 a month. That was the going rate for an associate. And you could get quarterly bonuses based on various things. Bill Ortale taught me how to evaluate a lawsuit using techniques that I still use today. John Kelley was president of the Bar Association and died young, I think at age 48 of cancer. He was a really fine man, a lawyer of the old school. Frank Drewota, later Chief Justice Drewota, was a chancellor then in his 30s. He was a great mentor to both Malcolm and me, someone who could answer all your questions. And we knew him very well, in particular, we meaning Malcolm and I, because Malcolm had clerked for him while in law school. Jim Sasser, who later was a senator, was a great mentor for me in so many ways. And there's so many others later on, but in my early days, those were the ones that made the biggest impressions on me.
So With regard to law school, as most of us in the bar get asked a lot by young men and women, they ask us if we think they should attend law school for various reasons. What advice, if a young person asks you today, do you think they should attend law school? What do you tell them? And if they do go to law school, what advice do you give them upon entering law school?
I think that's a much more complicated question today than it was when I was young. Part of my decision-making process was that that's all I'd ever really, truly wanted to be. I was encouraged to go to graduate school in history, and I had some thoughts about that. I had one professor at UT who encouraged me to go to Iowa to the MFA program in classical rhetoric. I had something of a talent for that, but I think that would have been the most tedious, boring experience of my entire life. What I've found about law is that if you're in the right circumstances, it's constantly changing. There's new challenges. You meet very interesting people. But I think what you don't see as much today is the idea that this is just who and what I am as a lawyer. And those who are looking at it as simply a means to an end, I don't relate to that. And I think those are the people who can get burnt out. I think there are a lot of women who want to do it and want that sense of achievement, but they wind up not practicing law in higher percentages. I don't think that's because they're less smart or less diligent. I think it's because there are life circumstances that crowd them out in such a way that they don't necessarily, at least at this time, discourage male lawyers from continuing. It can be very stressful unless you learn how to deal with it. Over the years, when I was young, lawyers dealt with it with one particular way: Scotch whiskey. And I didn't know a teetotaling lawyer until I was much older. That's not healthy. I think you should have some kind of enthusiasm for it. I don't mean to be an enthusiast, what we call an enthusiast, but some kind of idea that this defines who you are in a way that's different from other occupations that you could pursue. It's very hard to describe that. So I don't know if I would encourage a young person to enter it today or not. The means of communication are so different. The lack of civility is alarming. And the idea that I'm going to do this way because of a set of internalized values that you believe are important, that's the way I was brought up in the practice of law, and I don't think that's ceased to exist, but I think it's diminished.
Well, that leads into another question. How, in your perspective, I know the size of the bar has grown exponentially since you first joined the bar or were admitted to the bar. I practice law in the Stallman building now, which was once the epicenter of the legal profession in town, and is now mostly condos, even though Hal Hardin is still there.
Well, it went through a brief period when it was also déclassé, when Tom Shriver was accidentally overheard referring to some lawyer over there whose name I know but I won't mention as a Stallman building hack, and probably because this fellow ran against him for district attorney. That's not been true for a long time. I hasten to add that. Stallman building was the first building in Nashville with a powered elevator. Robin Cooper, the man who fired the shots that killed Senator Carmack, had his office in the Stallman building. It used to have around the top, what do you call that? Is that a frieze? But you know, when it has all these figures, like carved figures around the top, it had that very handsome building. They started falling down on top of people, and so they had to take them down. It used to have it had a place there with a great big round table where the lawyers would gather for lunch. Later at Satsuma, which was on Union Street, right at the alley, and that's gone as well.
Now, did you ever have any experience of the old original Gerst House, or any iterations of that?
The original Gerst House was on 2nd Avenue, and those buildings, when I was in law school, were still there, but it was part of a big project, and they were all pulled down, and the Gerst House had moved. The Gerst House that figures most prominently in my recollection was across the river. It was torn down when they built the football stadium over there. That was a place that was always filled with lawyers. They served these big fish bowls of beer, and I'm sure there were a lot of lawsuits settled over there back in the days before emails and before mediations.
Now, you mentioned you, out of law school, you joined up eventually, or maybe immediately, with Ortale Kelley. What were
After about 2 years.
So what were your first experiences out of law school, early clients, cases?
Well, I'll tell you one of the very interesting ones that I still think about. I was employed by an organization called Americans United for the Separation of Church and State. My personal experience with them was, as a boy, one of their representatives came to my church, a Baptist church in East Tennessee, because they were concerned that President Kennedy, as a Catholic, was going to turn the country over to the Catholics and to the Pope specifically. Later, Americans United came to be seen as a sort of an atheist organization. I didn't look at it in any of those ways. They had passed a law, the legislature passed a law providing that the book of Genesis had to be taught side by side in the classrooms with scientific theories, specifically including evolution. That's pretty plainly unconstitutional. Because of concern the Supreme Court was veering to the right, this organization wanted to build a body of state law. So I filed that lawsuit in Chancery Court. Ben Cantrell was the chancellor, and I had a variety of names I could choose, and the ones that I chose were Steele versus Waters, because I thought that had a wonderfully biblical sort of sound to it. There was a UT law professor who was rather proud of himself, and he had filed suit in federal court for a group of biology teachers. He came to the courtroom in my case and tried to get it dismissed so that he would have the case. His name was Fred Leclerc. Mr. Leclerc, I told him that this was unconstitutional and that this judge would do the right thing, and he did. It wasn't even a close question. That case went up to the Tennessee Supreme Court, and that was the first big, highly publicized thing that I was involved in, case I was involved in. They allowed the press into the Supreme Court into the courtroom, had a whole bank of microphones all over the place, had standing room only, people standing up around the wall watching the case. And one of my old Vanderbilt law professors, Hal Bigham, came to defend the law. He was a devout Church of Christ member, and he came to defend the law, and we argued that. The federal court had declined to hear it based on abstention, deferring to my case. That was appealed to the Sixth Circuit. Well, the Sixth Circuit Court of Appeals rendered an opinion declaring the law unconstitutional the very same day the Tennessee Supreme Court did. Some might think that was a coincidence. I didn't. The Court of Appeals took a lot of political heat off the Tennessee Supreme Court. But that was that great court back in the day that had Justice Henry, Joe Henry, great court.
And so how long did you work for Ortale Kelley?
I worked, I think, about 3 years. I was asked by Jim Sasser to put together his compliance package, they used to call it, because he was going to run for Senate. I did, and
what year was this?
Well, the election was in '76, so this would have been sometime in '75, and so that was 3 years out of law school then. I was already working for Ortale Kelley then, and I got it all filled out except for the treasurer. I called him and I said, tell me what name to put down here for treasurer. As you know, there was always a custom to have someone like Frank Gorell or someone with political, with a lot of political juice sign on for that because there was no work required. Unfortunately, this was the first statewide federal election after Watergate and the post-Watergate amendments to the Corrupt Practices Act. And it imposed personal criminal liability on the treasurer. So when I asked Jim Sasser that, he said, oh, Gary, just put your name down. We'll figure it out later. You've seen those comedic scenes where there's asked for a volunteer and everybody takes a step back and you're just left standing there. That's how I became treasurer for Jim Sasser for Senate. I thought about, when he was successful, I thought about taking a job with a Senate committee. And part of me will always wonder how my life would have been different had I done that. But I had a small child and I was doing pretty well. So instead, I was appointed an assistant United States attorney, which was a fantastic job, best job I ever had. If you could have put 2 children through college on that money, I'd probably still be there. But that's how I wound up at the U.S. Attorney's Office.
And what years were you there?
I stayed there for a little over a year. This was like 78, 79, somewhere in there. I can't quite remember. I was offered a job with a multi-state firm. Barnett and Malaysia had offices in Louisville, Frankfurt, Nashville. They were opening one in Nashville, Washington, D.C., Atlanta, and Palm Beach, Florida. And I thought I had an understanding, I'll put it that way, that I would be the United States Attorney in the second Carter administration. So I thought if that doesn't work out, you know, at least I'll have a job with a outstanding firm. So I went with them, and you know what happened to the second Carter administration. I have come to despair of it.
I know. Who was the U.S. Attorney when you were at USA?
Hal Hardin. And but the real interesting thing that happened from that, when I left, Judge Morton, who was the chief judge, called me and asked me if I would be on the panel to accept appointed federal criminal cases. They were just forming it. They had a federal public defender, but of course you've got numerous conflicts that arise. And he wanted me to be on the panel because they needed someone with some prosecutorial experience so they'd have fewer what they call 2255 petitions, habeas corpus type things, ineffective assistance. And so when the chief judge asks you for a favor, the response is, well, of course. And so I did that. It paid $20 an hour out of court and $30 an hour in court. And the fascinating thing that came from that is that I wound up being appointed to represent Eddie Sisk. Eddie Sisk was counsel to Governor Blanton, and he was under indictment in the so-called pardons and paroles scandal, accused of being part of a conspiracy to accept money for clemency for prisoners. And so that put me into the middle of something that I was way too young to deal with. And you're on the elevator, and the elevator door opens, and all the press is right outside the door with their lights to the point where you can't even see to step out. That was an odd experience for a 30-year-old, 31 maybe. We, for a brief shining moment, we had that indictment dismissed in Cincinnati. They had declared in the indictment that the racketeering enterprise was the office of governor of the state of Tennessee. And I told the Sixth Circuit that I understand who won the Civil War, but still it is inconceivable that the framers of this Constitution would have viewed the office of governor as merely an entity in interstate commerce. The 3-judge panel agreed with that and dismissed the indictment. They got an en banc and were able to sustain it in the en banc. by what I would say, with all due respect, a disingenuous argument. The idea that you can amend it on appeal after the to say that the racketeering enterprise is 2 or more persons associated in fact, although not a legal entity. Judge Edwards, who's the chief judge, asked me if that wouldn't state an offense. I'll never forget this. I held up the indictment. I said it would have, but it's not in this document, and this plea was entered based on this document, and our appeal is based on this document, and your duty is based on this document. And he asked me about another case called, it was the Dewey-Durham case, an unreported case, but he had written it, and basically holding that they could do that. And I looked at him and I said, "I say this with all trepidation and certainly with all due respect for Your Honor, but that case is just wrong." And Judge Lively was seated next to Judge Edwards, and he leaned back roaring and elbowing the guy next to him, laughing, because he was on my 3-judge panel. And Judge Edwards looked like this foul odor had entered the room. Those 2 votes on the en banc went as you would have expected. And so Eddie went off to jail. That was a difficult experience because Eddie, whatever he was accused of doing, whatever the facts are, was an immensely likable person, and still is. He's still living.
And now that was a pretty, in the second half of the 20th century, that was a pretty significant event in Tennessee history. What was your recollection of that? I mean, as a lawyer practicing here in Nashville, Tennessee, the way that whole process went down, the governor was sworn into office early. Hal Hardin, of course, played a key role in that. What was it like? What was the legal environment like in Nashville during that whole process, even before you were appointed Mr. Sisk?
The essence of it was, on the one side, there were people who thought that was a coup. That's Hal Hunt, who wrote about that in his book, titled his book "Coup." It took some stretching of precedents, I think, to do it. But those who lined up in favor of it were going to make sure that it was never seriously challenged, and it wasn't. What happened was that there were a whole series of clemencies that were waiting to be signed. The way the government set that up, they called it codename Tenpar, is that they were seeking clemencies of men, these were all men, who were so despicable that no reasonable public official would ever grant them clemency. And there was the highway patrolman who was also a personal chauffeur for Gene Blanton, who was Governor Blanton's brother. He was on video counting this money out, marked money, in a hotel room in Memphis, Tennessee. When Eddie was arrested at the state capitol, he had some of that marked money in his pocket. So this is before I was representing Eddie, is when all of this part went down. They feared that Blanton, either because he was bribed, which he was not, I don't believe. I think there were bribes, but I don't think it was Ray. But be that as it may, he was out of pique, out of spite, out of resentment, and out of Scotch whiskey, was going to grant all these pardons and let all these terrible people out of prison. And the whole idea was to prevent that from happening. That is how Lamar Alexander became governor many days earlier. He'd already been elected, but he hadn't been seated. And I think it was portrayed then and is portrayed now as a great, heroic, bipartisan effort. Even though Blanton was a Democrat and Alexander was a Republican, all of those who did this were Democrats. Joe Henry was a devout Democrat. The Attorney General was a Democrat. The Speaker of the House, and the Lieutenant Governor, all these people were Democrats, and it was a great act intended to be statesmanlike. and I think it was taken that way. But it was very little else talked about at the time.
And so early on in your legal career, were there any lions of the bar, so to speak, or any particular attorneys that you looked up to or revered here in town and the bar as it was at that time?
Well, there certainly were, and I'll probably omit some and regret it later, but the first lawsuit that I ever tried to a jury, my opponent was Mr. Tyree Harris Sr. His son is still a lawyer here. He was called Big Ty. Mr. Harris had this booming patrician voice, this great baritone voice, wore expensive suits, had French cuffs with locomotives as his cufflinks because they represented the L&N Railroad. I had an expert witness, an economist, and I learned how to cross-examine expert witnesses from that trial and from Mr. Harris. He dissected this man and destroyed him in ways that I would stop today. I would know how to do it today, but I didn't know how to do it then, since this was my first jury trial ever. So I learned quite a bit from him. Jack Madden was a great lawyer. He had a decisive way about him that's hard to describe. He was born in the Belmead Mansion, and he was to the manor born, and he understood this, but he was not overbearing. He was very solicitous and kind to young lawyers. Lawyer who I really wish had lived long enough for me to have more experiences with him was John J. Hooker Sr. Mr. Hooker Sr. was one of the great lawyers that ever came through here. And when I was law clerking in the firm that Jim Sasser was in, I was taken to a discovery deposition just in a routine car wreck case, Hooker's client. And I was a second-year law student, and he was the most famous lawyer in Tennessee. And he treated me like I was the Chief Justice of the Supreme Court. I never forgot that. There are so many others over the years. Frank Derwoda was a great mentor, person that you could call. In those days, other lawyers in the courts would take care of young lawyers. So I could get appointed to guardian ad litem matters or conservatorships or things of that nature. If I had a question, a real puzzling question, and it wasn't a case that the chancellor had, then chancellor, I could call him up and he'd spend 15 minutes with me talking to me about it, what to do, what not to do. I went to a lot of depositions with Jim Sasser. People think of him as a senator, of course, and a politician, which he was, but he was a very good trial lawyer, and he helped me see that some things that were so upsetting to me were just routine. They weren't intended to be personal. And that was a big, big tenet of the bar then, that nothing was personal. That no matter how you quarreled in the courtroom, when you walked out that door, you were friends again. So there are a lot of people like that. I think there were people who made impressions on me over the years. Jim Neal he was a very impressive person, and I mean this respectfully, but he was the most effective self-promoter I ever saw. Now, you know, he deserved the attention too. But he was awfully good at that type of thing. When I started practicing law, there were about 500 lawyers probably, maybe half of those active in the courts. On a Friday morning, they're all there. They're all at the courthouse on the motion dockets. So you could see the people who were really, really skilled. People like Doug Fisher. Doug is still living. I try to have lunch with him once a month. He's a person that I described one time in a motion as litigating with him was like being pecked to death by a duck. Judge Gaden thought that I had invented that phrase. I hadn't, but he's told people for years that I invented that phrase. But the key part of the phrase was not that I told it, it was that it perfectly described Doug Fisher. He's the greatest technician you can imagine. So he was a big influence on me, and in a lot of ways still is.
Of all the things you learned by watching these other great lawyers, what do you think is the most significant skill as a litigator that you've picked up from these other lawyers, or that you've learned in any manner of your career?
I think one characteristic of all great lawyers is that they're prepared. That kind of meticulous preparation. And when I was young and intimidated, I tried to overcome that by walking into the courtroom with the idea that I knew more about this case than anybody else in the room. That served me well over the years. One thing that I learned many years ago as well is that every case has a weakness, and it's a matter of finding and exploiting that weakness of your opponent's case and diminishing and avoiding the weakness in your own. But you got to be very clear-minded about it. You got to see what your problems are as well as your opportunities. But from the time you walk in the door of that courtroom, what a great trial lawyer is doing is trying the lawsuit, hopefully trying it around the weakness of the opponent, so that the opponent concludes. Back up a minute. You don't always have to win. You have to convince your opponent that he's lost. That's what happened to Hooker at Chancellorsville. That's an old story, and that works. And so also pick your fights. One of the worst things that you see in young lawyers is that the way they pick a fight is if they can identify it, they pick it. That's tedious, and it doesn't help your case. You got to figure out the fulcrum, so to speak. It's there. It's there in every case. Now, if your best shot won't overcome them, settle your case because, you might as well not just try it on a whim or a hope and a prayer. But that's more important than oratory. The other most important thing about your lawsuit that doesn't really relate to the lawyers themselves is your client. If you have a triable case and your client is slightly more likable than your opponent, you have an advantage with a jury. Juries don't always do the right thing, but in my experience, they want to. For the most part, I've had a couple where I didn't think that was true, but it's been rare. And if you can lead them into what they can go home at night and say, I did the right thing, then you're going to set up a powerful conviction in them, in their hearts, so to speak, that your opponent's not going to shake. Figuring what that is takes experience, judgment, I guess, but it's there in almost every lawsuit.
Now, you've represented clients in various capacities, criminal law, civil, done a little bit of everything over your career. What do you feel was the most significant case on which you've ever worked, as far as, maybe that you took it the highest you've ever taken it, the U.S. Supreme Court perhaps, and then also, aside from that, what was maybe the most significant case on which you worked that you either really enjoyed, thought it was a really interesting question of law, or just had a really good battle with another lawyer?
I guess the most significant case in terms of its notoriety would have to have been Eddie Sisk, but it's still being written about. I mean, the circumstances are not trial. We didn't have a trial. That certainly. I had a case against the old Third National Bank, a lender liability case that had good lawyers in it, and we got a judgment for $1.6 million on that case back in the 90s. I was probably happier with the lawyering I did in that case more than any other that I ever did. The case that got me involved in doing employment work was Wilson versus Sony Tree Publishing Company. Dan Wilson, who's passed away now about 2 months ago. Dan was what they call a song plugger. He was fired and replaced by a young woman, a female 20 years younger than he. And he was referred to me by a great songwriter, really great songwriter, Bobby Braddock. Braddock wrote "He Stopped Loving Her Today." And so I agreed to take that case on. I learned employment law in that case. It went to the Court of Appeals. We tried it 3 times. We had 2 hung juries, and finally got what was at that time the largest verdict in an employment case in Davidson County. That's probably been exceeded by now, but $5 million was the original verdict that we got. I learned so many things in that case, and it was heavily and well defended. That was in 1996, and I've been doing employment work ever since then. One that I'm really proud of, though, was the Lopez case, which you participated in. We were able to get monitors placed on all special needs buses because of that. Initially, because of the publicity it generated, Mayor Dean, when he came into office, demanded that they provide the monitors on those buses. We were able to get the Justice Department to intervene on a Title IX basis, and the agreement that was reached, the consent order that was submitted with the metropolitan government, required those monitors. I think we did a lot of good with that case. And sometimes you get the great pleasure here in this work of making money doing something that's good and worthwhile. Not always, but I think that was one of those cases. We wound up settling that one. I would say that you know, there have been a lot of small cases that don't mean anything to anybody that taught me things, where the other attorneys have taught me things. And that would take the rest of the afternoon to talk about that. Those cases really, really stand out. There was a case involving the Contribution Among Tortfeasors Act, those situations that went all the way up to the Tennessee Supreme Court. Doug Fisher was on the other side of that one. I learned a great deal in that case, learned a great deal from Mr. Fisher. There have been a great many. I've been at this 43 years, so there's a lot of stories, some of them tedious.
Well, one thing all of us as lawyers face is trying to find that balance between our devotion to our oath and balancing the practice of law with family and other extracurricular activities to try to find some balance in our life to the extent that's possible. Tell us about your family and then any other extracurricular activities. I know you coached basketball, those types of things that kind of gave you a step away from the courtroom, so to speak.
For 24 years I coached basketball. 17 of those, it was exclusively AAU ball, and these are travel teams. And through that, I got to meet a lot of people I would not otherwise have met. And I don't just mean well-known people. I mean guys who were coaching in other cities, and developed so many friendships. I got to become good friends with people like Coach DeVoe, Don DeVoe. I knew all of the Vanderbilt coaches because of that. We had probably over 50 boys over that period of time that went on to play Division I basketball. I'm still friends with Rick Bird. Coach Bird let us use his gym over at Belmont for our practices. He's really an outstanding coach. that was a great relief. It was competitive, which spoke to my competitive juices. But also it was a chance to learn and understand things and build friendships with these players, with these boys, and I still have those boys call me from time to time or send me cards.
And who was the best player that you ever coached and then perhaps witnessed playing on the other side?
The best player I ever coached plainly was Sean Marion. Sean played on the last team that I coached, which was in the summer of 1997 in the AAU National Tournament at Wake Forest. Great player. Sean didn't qualify. He went to a junior college, led them to a national JUCO championship, and then played 1 year at Nevada, Las Vegas, and then came out declared for the draft. He was the 9th player taken in the draft. His first contract was, I think, $6 million. He's made quite a bit more than that since. Sean, this year, he is retired. This was his last year in the NBA. He played several years with the Phoenix Suns, where he was drafted. He was traded to Miami in the Shaquille O'Neal trade, got a cup of coffee up in Toronto, wound up back in Dallas and got an NBA championship ring at Dallas, and spent his last year with the Cavaliers playing with LeBron James. So I think he was certainly the most talented player I ever had. I think the most talented player I ever encountered in AAU was Penny Hardaway. There wasn't anything he couldn't do. He had incredible vision, 6'7". If you tried to double team him, he'd just go over you and throw the ball to the open man at the other end, because there always was one if they're double teaming you. He could do everything. Years later, I found a scorebook from a tournament here that we put on, a game that was out at Hunter's Lane, and I was looking down through it, and there's Anthony Hardaway, said 55, and I thought, I didn't remember that being his number, and I looked over, no, that was the points that he scored, not the, not his number.
And he was from Memphis, of course.
Yes, and I saw a lot of great players other than that, but I got to see him up close and personal many times, talk to him. He was a great player. And
as many of us lawyers do, half-jokingly, we tend to get involved with politics. Have you had, you mentioned your experience with Senator Sasser. Have you been involved with any other political campaigns or run for office yourself? Or
yes, all of us have skeletons in our closet. I grew up in an intensely Republican area. My mother was on the Hamlin County Republican Executive Committee. The first candidate I can recall actively working in his campaign was a candidate for sheriff of Hamlin County, a Republican, and he won by fewer than 20 votes, and I learned after the election was illiterate. I went door to door for Barry Goldwater. I was one of Barry's boys. When I got to college, I became steadily disillusioned with all that. Let's see, what year would it have been? 1966, I worked all summer for Howard Baker in his campaign. My main contribution to that was that I came up with a theme for him. This is before the viciousness that we see today in politics generally and Republicans specifically had entered the scene, and Governor Clement was, by any measure, a great man, but he had some personal weaknesses that people talked about, that he talked about and acknowledged, but you wouldn't put those things in an ad or on television, more of a whispering campaign. So I suggested they use the phrase, "You can be proud of Howard Baker," and they did. They used that. By the time I was in law school, I was at least indifferent and in most respects a Democrat. My ex-wife became a member of the State Democratic Executive Committee because an old dear friend thought we could elect young people to the state committee if they had ballot primacy, and my name was B. So he took a petition down and filed it, and to file it, and found out that Harry Asquith had already qualified, so he changed it. He just put Mrs. in front of my name, which is how women properly identified themselves back in those days, and signed my ex-wife's name. And one of her opponents was diagnosed with cancer and withdrew, and she wound up on the state executive committee. To say that she had no interest would grossly exaggerate her interest, but she wound up casting a vote for Jim Sasser for state party chair. So by that time I was fully wedded to the Democratic Party. I went for several years not participating much, and then finally I worked in 2007, did a lot of work for Bob Clement, who was running for mayor, and as is the case with most of my candidates, he narrowly lost. Then my wife, now Melissa, ran for General Sessions Judge in 2014, and was successful. Was elected Division II General Sessions Judge, and is also has the Mental Health and Veterans Court in addition to other duties. That was an intense statewide campaign. I mean, a countywide campaign. This is you don't realize how big this county is until you get into one of those. So, in that same year, I ran for and was elected to be a member of the Tennessee Democratic State Executive Committee. I serve that now in that position now. In fact, I may be your committee member.
Probably. Now, we can all be forgiven our youthful indiscretions. Now, you mentioned Judge Blackburn, your wife. Do you tell us about your children? I had with my ex-wife two children, Catherine, who's now 39. She also is a lawyer, not practicing right now. She's living in Houston. She is licensed in 3 states, but living in a 4th. In Houston, Texas. She has two children, my grandchildren, who are 6 and 3, Evelyn, Evie, and Davis. My son, Ben, is 32 years old. He works in developing computer apps on an entrepreneurial basis. Then I had 2 stepchildren, Emily, who graduated from Ohio State and presently, to our great consternation, still lives in Columbus, Ohio. She's 26 now. Youthful indiscretions.
Yes. And I had another stepdaughter that passed away in 2004, Liz.
So, as a young lawyer, I like to hear stories about the old lawyers, or things that I can't imagine taking place in a courtroom or getting away with in a courtroom these days. Do you have any particular stories that you've recalled or have heard first, second, third hand that you'd like to share?
Well, I could spend the rest of the evening doing that, but I'll pick out a few. I told you about Mr. Harris, Tyree Harris, and that he had shown me how to destroy a expert witness. I can tell you a little bit more about that. I won't use his last name out of respect, but this expert first name was John, and he was generally known as Shaky John after this. When you're trying to establish the present value of the income stream of a person who's passed away, the discount rate is the most important number, because that'll affect everything else and affect it drastically. So Mr. Harris took the deposition of my expert witness, and he just asked for certain basic things. What did you base this on? What did you base this on? And he didn't attempt to cross-examine him at all. And in my naive little world that I was in, I thought, well, he didn't get anything out of that. But of course, he had done this quite a bit longer than I have, and he had gotten a lot more out of it than I realized. So he's cross-examining. Well, I think the guy's gone. I will tell you his last name. It was Moore, because you'd have to hear, I just today hear Tyree Harris's voice. He had gotten several different computations made of the effect of changing the discount rate, changing it from 9 to 8 to 7, whatever it happened to be. And he had this little scraggly piece of paper, and he had a golf pencil, the kind you use to keep your score on a golf cart. And he pulled out a newspaper. He said, "Now, Dr. Moore, I have a newspaper here from yesterday. I just didn't have time to pick one up today. This says Bonds AT&T. Now, that's the phone company, isn't it? You'd agree with me that the phone company is pretty safe investment. Yeah. If you buy these bonds, you put all of this money in here at their rate, which is 8%. Make me a computation of that. Can you put your head to that?" So this was when the kind of little pocket computer calculator that you now get given to you as favors was $100. That's how long ago this was. He starts trying to compute this. Meanwhile, Mr. Harris takes his pencil and licks the lead end of it and pretends to be figuring, and before Moore can get to his number, he supplies him the number. Is that right? And of course it was right. So he goes to 2 or 3 of these every single time, licks the pencil, scribbles on it, and waits on Moore to come up with the answer. So the lawyer with the pencil has arrived at the answer before the PhD economist has, until finally, of course, he put him under so much pressure that he made a mistake on his calculator and got it wrong. So not only was Harris's version sooner, it was correct. It was better. I learned a great deal from that. There have been some real characters that have come through here. This is not a lawsuit story, but there was a fellow named Zuccarelli who was not very successful, and the lawyers had gotten together before metropolitan government and got him appointed a city court judge, like a municipal judge of some kind, which worked pretty well until he pulled a gun on a litigant one time. And this resulted in him not being a city court judge any longer. And he would go all around the courthouse. He wore loose-fitting suits that were hand-me-downs, and he always had a little pad under his arm, and he whistled all the time. You never always knew where he was. He'd go up and look in the window in the courtroom door and look there like he's looking for a client. We hadn't had a client, in years. Judge Robinson, not our current Gail Robinson, but his dad, would appoint him sometimes to little general sessions things and let him try a case there. One day he just did attract an actual client and wanted to meet him. In the Stallman building there was a law library. We used to have law libraries before they were on a little electronic screen. And he went over there after hours and it was closed, so he got a brick or something and broke the window glass out of the door and unlocked it and invited his clients to come in and meet with him. This was not well received by the Bar Association, so he was barred from there. One of the biggest characters I've ever seen was the late, great Bill Moody. Moody was a guy who told stories that I can't really tell on the air from his World War II experiences. But he would do or say anything. If he went to a rural area defending a case, he would get there early and put the hood up on his car right outside the courthouse where the jurors would file in. So it looked like he was just a common man and he's there working on it, tinkering on his car with the hood up while the jurors are all coming in. I tried a case with him in Murfreesboro several years ago. There were 3 nurses who were witnesses. And he's doing his closing argument, and he always did this "I'm old, I can't remember" act, which he did always. And he said, now there were these 3 ladies that testified. He said, I can't remember their names. Let's see, there was Elaine, the redhead, and the fat lady, which caused one of the female jurors to just about faint. So with Moody, you'd either kill him or he would kill you. There was nothing in between. He had a lot of stories involving old Mr. Enoch's African-American lawyer, who himself intentionally made a character out of himself. Can't tell those stories either, unless this is placed under seal. Oh, let's see. Oh, I mentioned Jack Madden. Judge Morton was prone to interfere in your lawsuit, ask questions, intrude himself in your lawsuit, which are, these things are really not well received by lawyers. Trial lawyers don't like that. And he had a plaque that his brother had given him. His brother was George Morton. George was a campaign manager for Howard Baker and had no desire to be a federal judge himself, so he prevailed upon Senator Baker to recommend to President Nixon the appointment of Judge Morton. He gave him a sign. It said KYDMS, which stood for Keep Your Damn Mouth Shut. And he had it on the bench. Jack knew about this, and Judge Morton was interfering more than Jack thought was appropriate. He asked to approach the bench, and Judge Morton was always very terse and very quick, you know. Approach, Mr. Madden. What is it? What is it, Mr. Madden? So Jack doesn't say a word. He just walks up to the bench and just leans around and looks at the sign. and Morton was trying not to laugh. He says, he said, not a word, Mr. Madden, not a word, but he was trying to keep from laughing. I had a case years ago. I was on the board of the Nashville Bar Association, and my classmate, good friend Walter Kurtz, ran for and was elected Fifth Circuit judge. And this was a time when we were trying a lot of civil cases that aren't being tried today. Well, Walt got into that office and decided he was going to do criminal cases, and there was a lot of discussion about it, and it came up at a board meeting, and without realizing there was a newspaper reporter present there, I expressed my opinions, which happened to be he ran for that judge. He ought to be the judgeship. He ought to perform the duties for which he ran, which got into the newspaper. Later, we were in a lawsuit. I was representing Tractor Supply against a bank and one of the bank's customers. He finally concluded at the close of our proof that the bank did not owe a duty to the plaintiff. So he granted a directed verdict. Thereafter, I would come into the courtroom on motion days on Friday mornings, and every time I appeared, he would do 2 things. He would talk about, well, we have Mr. Blackburn here, who's a member of the famous class of 1972 at Vanderbilt Law School. He and I were classmates. And when I became a judge, he thought I should not be doing these criminal cases. He thought I should stick to the civil work, until one day I directed a verdict in one of his civil cases, and he concluded thereafter that I really was better suited for the criminal bench. So people would laugh at that. And it became almost a liturgy like the Episcopal Church. I would always say in response, yes, Your Honor, and as you recall, the Court of Appeals made the same mistake you did on that case. One thing I've found over the years is that you know, time goes on and you feel more comfortable doing things in court because you know these people, and you, for the most part, at my age, I've known them, certainly locally, I've known them before they were judges. And you know, you have to be respectful. You can't let yourself get out of control, but I can do a lot more teasing now than I used to. That case I had with Mr. Fisher, Doug Fisher, that went to the Tennessee Supreme Court, there were two things from that I recall. I told them that after his presentation that Mr. Fisher, and I said I mean this as a compliment, not a criticism, he has the ability of making the most preposterous arguments sound so very plausible. That's what he's done today. This case had gone on forever because the impact of McIntyre, the comparative fault, and all this sort of thing. It had been to the Court of Appeals 3 times and to the Tennessee Supreme Court. It went on 14 years, the longest one I ever had, and from the time it was filed. So I reminded the Supreme Court of the Jerry Clower story about John climbing the tree to knock this raccoon out of the tree, only to find a bobcat in the tree. And there's all this wailing and carrying on in the tree, and he's hollering down, "Shoot this thing, shoot this thing." And they reply, "Well, John, we might miss, we might shoot you." And he says, "Shoot up in here amongst us. One of us has got to have some relief." So I've had one of my great experiences as a lawyer was to make the entire Tennessee Supreme Court laugh at a joke. Didn't happen to be my joke, but it fit because we needed that lawsuit over with. And, so that one worked. I've appeared before all sorts of different characters as judges. One of the earlier cases I tried was down in Spain, and we tried it in an American Legion Hall because they had pulled down the courthouse and got into a political dispute and hadn't rebuilt it yet. And I'm sitting there and with the local counsel. This fellow with one of the loudest jackets I've ever seen outside of chiropractors walked in and said, "You boys ready to go?" And he's smoking a cigarette. And we said, "Sure." I said, "Oh yeah, sure." I turned around to my colleague there, Denny Mitchell, a very fine lawyer down in Sparta still. I said, "Denny, is that the sheriff?" He said, "That's the judge." That's how we open court. Old Judge Taylor in Knoxville was the one I mentioned had been appointed by Harry Truman. I was trying a case in his court. This would have been in the 80s. He was very old then, and he'd had some health problems, and he'd file the lawsuit in federal court, and he would set it for trial before the answer was due. He'd send you a trial date, and he was serious about it. It'd be like 6 weeks off, and I went over there on the case for Dairyman Incorporated, and there was a lawyer from our Washington, D.C. office looked over my proposed theories of the case. I had appeared before this judge before, and I knew what he liked. This fella said that was just entirely inaccurate. He would take it over. He would do it, show me a thing or two. So he put all this stuff together. I filed it. And I noticed when we went over there, he sat behind the bar back in the spectators section, and I'm up there, at counsel table. And Judge Taylor looks over his glasses at this and throws it straight up in the air. They're just papers coming down like snow. And he says, "I asked for theories. You've written me a book. This is a book." So the theories, the issues in the case were, did the defendant owe a duty? If so, did the defendant breach it? And if so, what were the damages? And that was all. It's all he would ever charge. I was trying a case in there. This was for Dairyman Incorporated on a truck accident. And he didn't like chiropractors. Judge Taylor didn't. And so the plaintiff called a chiropractor who had done this kind of a video. It's kind of hard to describe it. You're not old enough to remember those fluoroscopes at Sears. You look through the thing, look down at your own feet. It was that kind of thing, only it was a motion picture. But he had not furnished me a copy of it. I didn't know anything about it. And that was contrary to the local rules, plus outstanding discovery requests. So they called this fellow, and he's up on the witness stand. And I stood up and I said, Your Honor, I need to make an objection. That's about how far I got. He turns around to me and he says, sit down, shut up. That's how he ruled on my objection. But I got his attention, and he started looking at this fella. So finally, at one point, he's trying to set up his little video, and he turns around to the jury and says, can you see this okay? This would have, Judge Morton was Taylor was a real stickler on decorum. So I stood up and said, Your Honor, I don't believe a witness should discuss something directly with a juror. Well, Taylor just did this little blink and just went off on the guy, started screaming at him, you don't run this court, I run this court, get out, get out, get out. And he screamed at him all the way up the aisle and out the door. We got to the closing argument in that case, not the closing argument, right for the charge. And he's charging the jury, and he looks through the papers, and he says, now the plaintiff in this case is sued for $2 million. He says, Mr. Smith, whose name really was Smith, Mr. Smith, you don't expect to get that or anything approaching it, do you? He said, no, sir. That was one of the reasons that got reversed. We got a very good verdict, but it was reversed because of his behavior. But there was some things that he did. He would order the court reporter to strike things that he had said from the record, not to print them. He'd express opinions about the credibility of a witness, all kinds of things. And when he was charging the jury, there was a standard charge having to do with expert witnesses or witnesses who've been paid. And he's going, and if you read it, it's perfectly fine. But he's talking to the jury, and he says, now the defendant or the plaintiff has called witnesses, experts, doctors, people like that, and a chiropractor. And he's been paid. Now, it's not against the law for him to be paid, but you should accept this testimony with extreme care. And he'd point this little bony finger like he was out of Dickens. He told me one time, why was I over there representing this man whom I knew to be guilty, having been a former assistant U.S. attorney? And I said, well, it's my duty, Your Honor. He was a staunch Southerner. So I said, you remember General Lee said that duty is the sublimest word in the English language. And he sort of connected on that and went back and remembered one of his law professors at Yale, no less, had told him that the lawyer's responsibility was not to determine guilt or innocence, it was to represent the client. He did all of that, but of course you knew what was going to be the outcome of this motion.
Did you ever have anyone in the court remember fall asleep on you?
The late, great Harry Lester had a court officer named Josh Grider. Mr. Grider was a former Harlem Globetrotter, big guy, African-American guy. And I was defending a case for Budget Rent-A-Car. They had an accident caused by one of their employees, and Steve North represented the plaintiff. Well, he calls the young woman as a witness after lunch, the plaintiff. And she's testifying about the accident, and her mother's sitting back in the courtroom, starts bursting into tears. And he says, oh, and it hurt so bad, and she cries again. So I'm looking for a way just to disrupt this. And so finally she gets her way up to the emergency room and says, and then the doctor told me. Well, I didn't care what the doctor told her. I knew what the doctor told her, but I wanted to see if I could break this up a bit. So I stood up and I said, Your Honor, I have to object to I look up there, and Judge Lester he's completely inert, leaned back with his head on his chest, tipped over. And he had had some heart problems, later died from them. But I said, Judge, Judge, Judge. Couldn't raise him. So I turned around to Mr. Grider, and I said, the court officer, and I said, Mr. Grider, Josh, he's sound asleep. Well, Judge, let's say Judge and Josh had an affection for the same sort of lunch beverages, which was a big part of this. And so the jurors now are sort of tittering, and one of them gets up out of the jury box, goes over there and shakes Mr. Grider, wakes him up. And I said, Mr. Grider, we're concerned about the judge. And he looks up at me like this, and he says, Judge, nothing. Honest to goodness, I was worried at that moment that he had died. So Mr. Grider goes up there and shakes him awake, just like this. And he looks up like this and is confused and turns to me and like in wonderment. And I said, had a hearsay objection, Your Honor. And he turns to Steve and says, don't ask for hearsay, move on, move on. And I thought years later, if I were the age I am now, I might have tried to persuade the jurors and all of us just to go out in the courtroom and let them both wake up in an empty room. But I couldn't do that, because what if I'd done that and he was dead? Plus, I wasn't old enough to do that then.
Well, over your long career, you've been involved with a lot of different things, and one of which I know is the American Board of Trial Advocates. Before we wrap up here, if you will, just talk about that a little bit and what role, if any, you played in that and currently play.
That's an organization I'm really immensely proud of. It's a invitation-only organization of experienced jury trial lawyers, plaintiff and defense, and it's been around for many years. And the one who actually put my name up was Jack Madden to be invited to join. In 2007, I was the chapter president in Tennessee. We have participated in a lot of things. It's not a political organization, but we did contribute money and took the position that appellate judges should not be elected, that the amendment to the Constitution to make sure they continue to be appointed should remain, and that was successful. And through that, I've met so many wonderful lawyers. Actually through one of those events, I got to meet Sandra Day O'Connor, who came to Nashville speaking at one of the events. There was a lawyer from Louisiana named John Johnson, who got my name because of a BOTA, associated me on a case here, and that had been transferred from the federal court in Shreveport to the federal court here. I was telling you about how effective Tyree Harris was examining this expert witness. I saw an entirely different approach, just as devastating by John. He apologized his way through the whole cross-examination. He is a quintessential Southern gentleman, and he would say, now, Doctor, I'm obviously confused here. I was under the impression, let me just look here. Well, here's your statement. I'm under the impression that you'd said A, B, C, and if I'm not mistaken, it's probably my mistake, but I think that you said D, E, F today. Did I get that wrong? Well, one of the things that Jack Madden taught me was, if you're explaining, you're losing. And so this witness would then spend 10 minutes trying to explain this discrepancy, rather than John looking hateful or mean-spirited or anything else. Before that, back in probably the 80s, somewhere in there, I cross-examined an expert witness in the Sixth Circuit Court here. I thought I had this guy. I thought I had done as effective a cross-examination as possible. the case got settled while the jury was deliberating. One of the jurors came out, and the expert was a man named Fred Grimm, who was an opinion for hire. I mean that respectfully. We've hired him. But this juror was talking about why was Mr. Blackburn so mean to that nice Mr. Grimm? The fact that his testimony was nonsense was much less important to her than my demeanor. So I learned from that. I try to learn from everything. So later, I had a woman, a nice appearing woman, but who had contradicted herself multiple times, had had 2 accidents in 4 months, and had blamed all of her injuries on the first accident in that lawsuit and on the second accident in that lawsuit. So every step over to the courthouse, I was telling myself as a mantra, lower your voice, lower your voice, lower your voice. And so I apologized my way through that. And at one point, without any yelling or any meanness at all, she started crying. And the jurors, instead of looking at me, why'd you make this woman cry, start going, they start nodding their heads like that. There's so many things that can't be taught, you know, in a class. But you also have to have your own style, get your own style. I don't have trouble quoting the Bible, quoting Shakespeare. It feels comfortable to me. I know a lot of lawyers don't. They don't like it, don't feel comfortable doing it. So you just do what you feel best doing. When I was doing defense work, I would recite Hamlet's soliloquy because it was about suicide. I learned that in high school. Nobody told me it was about suicide, and I didn't figure it out for myself. And it talks about the to be or not to be, that is the question, whether it is nobler in the mind to take up arms against a sea of troubles and by opposing in them. It goes on to sleep, perchance to dream, sleep that ravels up the tattered sleeve of care. What he's talking about is that if you could simply lie down and go to sleep with all the miseries that we have to experience in life, and you just had a wonderful sleep, who wouldn't choose that route? Sleep perchance to dream, not knowing what awaits you. Conscience doth make cowards of us all. But the point of all that was he goes through all the miseries of life, one of which is the law's delays, the arrogance we face, the all sorts of things. And the point being, everyone in this life has suffered. Suffering is part of the human condition. I never gave that speech when I didn't have jurors nodding their heads. And I would say the mark of a man, mark of a woman, is not suffering, because we all suffer. It's how we deal with our suffering, whether we have the courage to live. That never failed me, that whole thing. As you can see from the parts I repeat now, I did it a lot of times. And then there's one final thing I would say. There was one course that I took in law school. It was a seminar called Law and Literature. And that is where I first read All the King's Men by Robert Penn Warren. Robert Penn Warren was one of the great fugitive poets here, associated with Vanderbilt. And he wrote this great novel set in Louisiana. It's basically premised on the life of Huey Long. And it shows, he has Huey Long, that character, Willie Stark was the name of the character in the book. And he's arguing with this very principled attorney general, an old blue-blooded lawyer. And what he's trying to do is to build a charity hospital, to do so much good for so many people. And in order to do this, he's breaking the law. He's doing various things that are against the law. So the Attorney General tells him that, "Governor, don't you know that's against the law?" And Governor Stark turns to him and he says, "The law. The law. Let me tell you what the law is. The law is a short blanket on a cold night and 3 in the bed. No matter how you tug it and pull it, it'll never cover it all." And that hit me so much that for a number of years I had that on my wall to show clients. And it can't ever do it. The law is part of a great, it's no longer an experiment, I guess, after hundreds of years, but it is a dynamic that understands and comprehends humanity and when left to work. It works. I'm proud to have done it. I didn't expect that, sorry.
All right, well, Mr. Blackburn, thank you very much. That concludes our interview for the Legal History Project for the Nashville Bar Association.
Thank you.
Thank you.